Welcome everyone, this is Amer from UCounsel. Today we'll talk about the computation of time as is required by the rules of civil procedure, so you can calculate the time correctly with respect to your civil proceedings in Ontario. We begin with our usual disclaimer that this course is not legal advice, so if you have any specific questions regarding your issues, you must contact a lawyer or a paralegal, or contact the Law Society of Ontario for any referrals. So why do we need to correctly compute the time? Why is it important? It's important, number one, because if you are not filing or serving or delivering the documents pursuant to the rules, and if you try to file a document with the court office which is beyond the timeline prescribed in the rules of civil procedure, the court office will simply not accept the documents. So they don't have this discretion that if you are late in filing some documents and you are being polite to the court office staff, that they will accept your documents. They will not. They will simply abide by the rules. And then if you're late or if you have not followed the timeline within the rules, then you will have to either obtain consent of the parties for the late filing, or you'll have to get a court order to change the timeline or file the documents beyond the timeline that is prescribed in the rules. So it is very important that you follow the timelines within the rules at the outset. Now, Rule 3 is in the rules of civil procedure is the one that deals with the computation of time, and I will give you some of the important aspects of that rule. A few things that you want to keep in mind is that when you are calculating time between two events, you exclude the first day of the event, the first event, and then you include the last day of the second event. Secondly, when you are given a time period which is less than 7 days, you do not count holidays when you are calculating a time period of less than 7 days. Now, also you want to keep in mind that when time expires on a holiday, right? So then whatever you are required to do, whatever the expiry date is on the holiday, you can do so on the next day, which is not a holiday. So for example, if something, the last day of serving some document was Sunday, then you could do it on Monday if Monday is not a holiday. Another part that you want to keep in mind is that any documents that you serve after 4 p.m. or on holiday, they will be considered as if they are served on the next day, which was not holiday. So that's important. 4 p.m. is sort of your cutoff time period of serving the documents on the same day. And the only exception to that is a document which is an originating process that is not considered here. Now, if a rule provides for a time of day in a specific delivery or service of document, then you have to treat that time as the local time in the place where you are serving that document. Now, let me explain these rules by example so that will be a bit more clear to you how you actually compute the time. Let's take the example of service of statement of defense, which is sort of a common document that you may need to serve if you are defending a court action. And the timeline for service of documents is in Rule 18.01, which essentially says that if you have been served with a statement of claim within Ontario, then you have 20 days from when the claim was served to deliver your defense, to serve your defense and file it with the court. But certainly the filing may be delayed a bit as long as you're not noted in default, but certainly the service of statement of defense has to be done in 20 days. So how do you calculate the 20 days? Let's take it by way of an example. So let's say that the claim was served on you on April 1st, 2019. So first event that occurred, which was the service of claim, was April 1st, 2019. Second event, which is going to happen, is the service of defense. So if you calculate 20 days, you exclude April 1st, and then you calculate 20 days, it falls on April 21st, 2019. Now, April 21st, 2019 is actually a Sunday. So second event is a holiday. So then according to the rules, statement of defense now is due by April 22nd, 2019. So you excluded the first event, you included the second event, and it so happens that the second event falls on a holiday, and so the next working day, the next day that is not a holiday, is April 22nd, and so your statement of defense is due on April 22nd, 2019. Let's take another example, and this is service of pretrial conference brief under Rule 50.04. Why I've chosen this example is because this is a time period which is less than 7 days. So pretrial conference briefs need to be served and filed with the court at least 5 days before trial. So let's take an example of that. Let's say the pretrial was scheduled at April 22nd, 2019, and you have to serve it by 5 days before April 22nd, 2019, and I've calculated this to be April 15th, 2019. And how did we do that? We excluded the first event, which was April 22nd, 2019, and then we do not count the holidays. This is a typo. This should be April 22nd, 2019. And then we do not count the holidays. And therefore, when we include the second event, the actual at least 5 days fall on April 15, 2019. And a lot of times people make this mistake that they don't, they end up counting the holidays, and then they assume that their time period for delivering the pretrial conference brief would have been April 17th, which is not the case. So if you show up on April 17th or 16th and try to file your pretrial conference brief at the court office, it will not be accepted. So it's very important to calculate these time periods correctly. Now, what happens when you are late in serving, filing, or delivering a document? What are your options? You generally have 3 options under Rule 3.02. Number 1 is that the court has this power to grant you an extension in time or abridgment, which is prescribed under the rules. So you can always bring a motion to the court, and you have to bring a motion. So it's a motion before the court, and you present your case and explain to the judge or master why do you need extension, and you justify it, and the court has the power to grant you that extension or abridge the time period. The second part that you want to remember is that when it comes to the time periods within the rules of civil procedure, if you have consent of all parties, then you can file that consent. For example, in delay in filing some document, if you attach a consent of all parties that all parties are permitting you to file a specific document with delay, then the court office will accept it. And the third point you want to remember is that if your matter relates to an appeal, then any extension or abridgment in time that you need from the court, it has to be granted by an appellate court judge. And a superior court judge will not be able to grant you this extension. So in the cases of appeal, you'll have to end up presenting your situation to an appellate court judge and seek his or her approval. Now, so in conclusion, what do you want to keep in mind? You always want to carefully compute your timelines, and obviously you don't want to wait till the last day. So if something is to be filed at least 5 days, it is okay to file that document 10 days in advance, because if you wait till the last minute or the last day, you may realize that when you arrive at the court office, you may not have the complete documents, or you may not have the documents in the form that the court office will accept, and then you don't have much time to fix that mistake and then go back and file your documents. So ideally, you don't want to wait till the last day, but at the same time, you want to make sure that you compute your time period correctly so that you don't have any mistakes. Remember that the court office cannot avoid the rules. If the rules dictate that a certain time period needs to be followed, the court office will simply follow that, and they do not have any discretion in bending those rules in your favor. And once you're computing the time period correctly and you're following the rules, it avoids you unnecessary hassle. You may have to bring a motion, or you may have to ask other parties to consent for the delayed time period, and depending upon the circumstances, you may or may not get a court's approval, or you may or may not get a consent from the party. So this is a simple procedural thing about calculating the time, and you want to make sure that you're not offside of the time periods that is prescribed in the rules of civil procedure. Hopefully that helps you in understanding the computation of time within the rules of civil procedure, and we'll see you in the next lecture shortly.